Tammy Cowan's is probably the most sophisticated informant in modern history because she is operating at a level of high proficiency. Like you mentioned the Terry White case, she gave Terry White up so fast and so cleanly that he didn't have an opportunity. He didn't know what hit him. He went to sleep, woke up in jail.
What would you have done if a man that you looked out for, his son, you kept his business alive, his brand alive, and then he come home and he go to your biggest op?
Big Meech did not have to sign his life rights over to Tammy Cowan's.
How could my friend send somebody to me through a DEA informant? And Tammy Cowan's been a DEA informant since like 2000, paid 2009.
It's been several months and the internet is still on fire with the whole BMF Big Meech Cuffy situation. What the majority of social media onlookers are missing is that Cuff's Frank's hearing would have never happened had Tammy not went to Cuff's defense team, attempting to clean up prior statements that she had made. It's no secret that Demetrius Flannery was moved around to several different yards during his incarceration. What is also not known by many is that Meech has never served time at an actual USP. All of his stints were done at FCIs. What is an FCI, you might ask? Allow me to break it down for you. The 5 security levels for federal prisons are minimum, low, medium, high, and administrative. The level assigned to a prison determines the physical security, staff to inmate ratio, and freedoms for inmates. Factors that determine security levels are: 1. Type of offense. The type of crime committed is a factor in determining the security level. 2. Risk of violence. Likelihood of violence is a factor in determining the security level. 3. Escape risk. Likelihood of escape is a factor in determining the security level. The acronym FCI represents Federal Correctional Institute, which is a type of federal prison that houses inmates in medium and low security facilities. Low security FCIs: A. House inmates who are considered low risk. B. Have dormitory or cubicle housing. C. Have a higher staff to inmate ratio. D. Have fences and electronic security systems. E. Have higher, tighter control over inmate movement. Medium security FCIs: A. Have strengthened parameters. B. Have mostly cell-type housing. C. Have a wide variety of work and treatment programs. D. Have a high staff-to-inmate ratio. E. Have double-fence perimeters with electronic detection systems. FCIs versus USP. FCIs are less volatile than United States penitentiaries, which are the most volatile of all federal prisons. With a case as big as the BMF case, one would think that Meech's and Terry's time would have been done at a USP. One of the biggest names brought up in Cuffy's Frank's hearing was that of Terry Bernard White, infamous Atlanta drug dealer and known snitch that was in a sexual relationship with Tammy Cowan. On December the 27th of 2011, Demetrius Edward Flannery, aka Big Meech, filed for a writ of cert. What is a writ of cert, you may ask? A writ of cert is the request to the Supreme Court to review a lower court's decision. In his case, Meech petitioned the court for a writ of cert to review the judgment of the United States Court of Appeals for the 6th Circuit Court.
The writ of certiorari, which is shortened usually to writ of cert.
What is a writ of certiorari? The writ of certiorari is a legal remedy used to review the decisions of lower courts, tribunals, or administrative bodies. It allows a higher court, such as the Supreme Court or a high court, to examine the records of a case and determine whether the lower court's decision was correct in terms of law and jurisdiction. The term certiorari is derived from Latin, meaning to be informed or to be certified. E. Features. Corrective remedy certiorari is a corrective remedy that aims to rectify errors made by lower courts or tribunals. Limited scope, it does not re-examine the facts of the case but focuses on legal errors, jurisdictional issues, or violations of natural justice. Quashing orders certiorari can quash the order of a lower court or tribunal if it is found to be erroneous. For issuing certiorari. Certiorari can be issued on various grounds: excess of jurisdiction, when the lower court or tribunal exceeds its legal authority or acts beyond its jurisdiction; error of law if there is an error in interpreting or applying the law, violation of natural justice, when the principles of natural justice such as audi alteram partem are not followed, procedural irregularities if there are procedural errors or irregularities in the proceedings, persons against whom certiorari can be constituted. Certiorari can be issued against judicial bodies, lower courts, tribunals, or quasi-judicial authorities, administrative bodies, administrative decisions affecting rights and interests. Essential conditions for issuing certiorari. To obtain a writ of certiorari, certain conditions must be met. Error on the face of the record. There must be an error apparent on the face of the record, such as a legal error. Finality of decision. The decision being challenged must be final and conclusive. No alternative remedy. Certiorari is not available if there is an alternative remedy such as an appeal. Procedure to file a writ of certiorari. A writ petition for certiorari can be filed either in the Supreme Court under Article 32 or in the High Court under Article 226. The petitioner must demonstrate the grounds for challenging the lower court's decision. Landmark cases related to certiorari. Side Yakub v. K.S. Radhakrishnan Ors. 1964, the Supreme Court emphasized that certiorari is not an appellate remedy but a corrective one.
The opinion of the Sixth Circuit Court of Appeals for a certificate of appealability is unpublished. Its order denying panel rehearing as well as its order denying rehearing are likewise unpublished. The opinion and order of the District Court denying Meech's motion is also unpublished. The District Court's denial of Meech's motion for reconsideration or alternative motion for certificate of appealability is not published in the Federal Supplement. On October the 28th of 2005, Meech was indicted for various drug charges. Indictment was superseded several times until a final fourth superseding indictment was filed on December the 15th of 2006. Meech maintained his innocence throughout plea negotiations, but nonetheless entered into a Rule 11 plea agreement with the United States of America on November the 11th of 2007. Therein, Meech agreed to enter a guilty plea in response to Count 3, which alleged a continuing criminal enterprise, and to Count 10, which alleged a conspiracy to launder money. The plea agreement provided that if Meech withdrew his plea before sentencing, he would waive any protections offered by Rule 410 of the Federal Rules of Evidence, as well as his right to direct appeal. Such waiver provisions also provided that the government could use Meech's testimony and evidence elicited through the Rule 11 proceedings against him in any other proceeding. The plea agreement did not, however, contain any provision requiring that Meech confess to the crimes alleged in the plea agreement, or supply the government with any statement or evidence to corroborate the allegations against him. Nonetheless, at the plea hearing, the trial court informed Meech that in order for the court to accept his guilty plea, that he needs to confess and answer certain questions in order to satisfy the trial court that he was truly guilty. If you are confused, allow me to clarify. What that means is Meech did not have to confess to specific crimes in the indictment, but would, however, need to testify truthfully to any other questions that the court imposed. The court further informed Meech that a guilty plea would continue a waiver of his right against self-incrimination throughout the course of answering trial court's questions. Specifically, the trial court instructed Meech, if he pled guilty, that he fully understood that he waived his right not to incriminate himself, since the court intended on asking questions about what he did to satisfy the court that he was guilty, and he would have to acknowledge the fact that he was guilty. The trial court also instructed Meech that if he withdrew his guilty plea for any reason, the government will be able to use his answers to said questions throughout the plea against him, to which Meech will reply yes. The trial court proceeded to ask Meech whether he was guilty of each of the charges contemplated by the plea agreement, and asked direct questions about the extent of his culpability. In addition, the trial court offered the government an opportunity to question Meech in response. Meech confessed, and by answering the detailed questions of the trial court, the government provided inculpatory testimony regarding the specific details of the charged crimes. Until that point, Meech had never confessed to any of the government's allegations and had not cooperated with the government for specific information related to his charges. On September the 12th of 2008, the trial court sentenced Meech to 30 years in prison, followed by 5 years of supervised release. However, the trial court insisted that Meech explain in detail the manner in which he committed the crimes alleged against him. This excavated Meech's ability to withdraw withdraw his plea before sentencing. Indeed, had he done so, Meech would have been confronted with his compelled confession at trial. The trial court's questioning during the plea not only infringed on Meech's Fifth Amendment rights, but it was unnecessary. Ultimately, the parties had already stipulated to certain facts. Worse, still, Meech's attorneys did nothing to protect him against his admissions. In the exchange between Meech and the trial court, notwithstanding that they could have invoked Meech's Fifth Amendment rights. However, even had the attorneys done so, Meech faced life in prison and was set to be sentenced by the same trial court. Thus, Meech was naturally hesitant to refuse to answer the trial court's question, for fear that the trial court would either refuse to accept his plea or would impose a harsher sentence upon him. Thus, Meech, like countless defendants across the country who enter into plea agreements containing Rule 410 waiver provisions, chose to not withdraw his plea before sentencing, and instead was forced to resort to other methods of post-conviction relief. Keywords: other methods of post-conviction relief. These methods are much less likely to ensure the preservation of defendants' constitutional rights, not necessarily burden the court system.
Today we are going to be talking about Rule 410, which states that a prosecutor is not allowed to admit statements made during the plea bargaining process against a defendant in trial for fear that the jury will interpret partaking in a plea bargaining process as an admission of guilt. Much like with a contract, the defendant has the right to withdraw his guilty plea at any point until it is accepted. Once the guilty plea is accepted and finalized, Rule 410 no longer applies. So Rule 410 actually has two exceptions. The first one is that if a defendant admits a statement made by the prosecutor during the plea bargaining process in the trial, the prosecutor might be able to admit something that the defendant said during the plea bargaining process if it requires clarification for the statement to make sense to the jury. The second exception applies only to prosecutions for perjury or false statement, so long as the statement was made under oath, on the record, and with counsel present.